Good morning, everyone, and thank you for joining us for our webinar, Your Land or Mine. In 1995, Nelson Mandela said, "With freedom and democracy came restoration of the right to land, and with it the opportunity to address the effects of centuries of dispossession and denial. At last we can, as a people, look our ancestors in the face and say, your sacrifices were not in vain." I think we all know that ownership and occupation of land is a highly controversial and contentious issue in South Africa. It is highly politicized, simply because it is a central social rights issue driven by the need to address past wrongs and distortions. My name is Richard Marcus. I'm a director in the Dispute Resolution Department of our firm. Joining us today are three colleagues. First, I'm very pleased to introduce my old friend and colleague, Con Hubert from SC of the Cape Bar, with whom we have worked for many years on matters of this nature. I'm also very pleased to have with me two of my internal colleagues, Sentabali Makara and Belinda Scriba. All of us have some experience, indeed extensive experience, in the application of laws relating to land and occupation and ownership and so forth. Each of them will be talking to topics in which they have experience, and you will certainly have an opportunity at the end of the presentation to ask questions. Please could you put your questions in the chat box, which I think that Andrew is assisting us, has set up, and we will collect all of those and try to answer as many of them as possible at the end. The presentation should take about an hour, and we have left time for those questions, so please feel free to consider this. This is your opportunity to get some free legal advice if you want it. The topics to be covered include, and we'll each be talking to them. Firstly, we'd like to talk about land and occupation rights in the context of the Constitution at a high level and case law. Con will be speaking to that to start with. Then we will turn to the practical application of dealing with the main legislation dealing with these issues. That's the PI Act and the ESTA. Some of you may be familiar with those, but we intend to try to present this in a practical way based on experience. And flowing from that, we'll look at issues such as actual practical situations where there is unlawful land occupation. We'll deal briefly with the issue of land invasions and how to deal with that. And once we've completed the three speakers, we will turn to the question time. So Con, let's begin with you. And perhaps the best way to do it is just to pose a question. Does legislation like the PI Act and ESTA unjustifiably infringe the property rights of landowners in a constitutional context? Over to you.
Thank you, Richard. Thank you for the introduction, and good morning to your listeners. Yes, the question that you have posed is an interesting one. I think it's a very valid question in the context of the topic. Unlawful occupation of land, your land or mine, which is a very provocative question, but it's a valid question, and I dare say an interesting one. So the question specifically deals with the, when you introduce the word unjustifiably, is there an unjustifiable infringement? Then you are immediately introducing the question play in legislation like this. Those two concepts underpin this legislation. Belinda and Sentabale will speak more, more to the specific provisions of those two acts, the so-called PI Act, Prevention of Illegal Eviction from Land Act, and the ESTA Act, Extension of Security of Tenure Act. But you will find when you listen to them that what those two acts do is they provide various procedural and substantive rights to people who are unlawfully on property. That causes quite a nuisance to some people. Some people don't find it difficult to accept that. Some people think it can never be just and equitable to detract from property rights, from their property rights, at least in the traditional sense of property and ownership. And so the legislation is often quite controversial. The question, if one can ask it, maybe in just put it in layman's terms, are these limitations on property rights, are they justifiable? Should we try to avoid complying with these obligations that are placed on owners as much as possible, or should we see this legislation in the context of of the Constitution, the history of the country? I think, Richard, you alluded to those words of Nelson Mandela quite aptly, because that is the context in which this legislation is located, and we have to be alive to that, and we have to understand that. It's also interesting because I think most people, well, probably every person on the planet has some sense of justice. We all think that our own notions of justice are correct and objective, and sometimes you'll find that that's not necessarily the case once it's challenged or interrogated. So part of what we will do today when we look at these things is to give ourselves and the audience an opportunity to examine our own thoughts about these concepts. So what I propose to do is to answer the question by referring to specific provisions of the Constitution that are relevant to this question, and then I will refer and deal with a specific judgment of the Constitutional Court, which, in my view, very eloquently and quite intensely deals with this issue and assists one to locate this legislation, as I say, in the correct context. So the purpose would be, when you listen to Belinda and Sentebale, and when you listen to what they say about the provisions, one will have an understanding of the context or where this comes from. And the purpose would also be to give audience an understanding of how the courts, particularly in this case the highest court, the Constitutional Court, thinks about these matters, which will be useful. If you ever find yourself in a position where you have to approach a court to get some kind of relief from unlawful occupation of your property, it's very useful to know how the courts think about this, and one can adjust your expectations and your actions accordingly. So, starting with the relevant constitutional provisions, I think a slide is made, and that will be helpful for audience members to see that as we go along. What we have there is firstly the preamble, and one sees that's not the full text, but in the Constitution, the preamble starts with "We the people of South Africa," and the very first line of provision is the one you see there: "Recognize the injustice of our past." So the concept of justice already plays a part there, and it's really all about that. It's also about the provisions relating to the rights of human dignity, which you'll find in Section 7, in Sections 1, 7, and Section 10. One will see if when you look at the jurisprudence, the right to dignity, obviously and quite self-evidently features very strongly in the consideration. So the human dignity provision, to read it in full, Section 10 says everyone has inherent dignity and the right to have their dignity respected and protected. And I don't think it would be contentious for people to understand that is a foundational value of our Constitution, and certainly our Constitution is certainly a meritorious one, if I could put it like that. The next provision that is very relevant is the property provision. If we can scroll down, or maybe just show the next slide. I think it's on the next slide, Section 25. That is actually section 25(1) sub 1, which says no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. So we will see when we discuss this legislation that there is I think I already mentioned it, but there is to an extent an infringement on property rights. And but it's in terms of these laws, this legislation are laws of general application. So it's admissible in terms of the constitutional protection of property rights to have legislation like that. That's the first point. And of course, the inquiry is there's always a tension between the property rights and the other social rights that we've referred to, and then particularly the next one, section 26, if we can go to that, that's the section that enables this legislation, that provides the source of this legislation, the right to housing, and the very first one, everyone has the right to adequate housing. State must take steps with its available resources, and then the one that is particularly relevant to eviction matters: no one may be evicted from their home or have their home demolished without a court order. So long gone are the days where you could evict someone even if they're unlawfully on your property without approaching a court. And the court, as I say, will ultimately inquire whether an eviction will be just equitable. What is very contentious often here is what is meant by a home. So I think Belinda is going to speak a little bit about that, but that's always interesting, because it's obviously an important aspect of this legislation. It's only if the property or where you are residing can be considered to be your home that you receive the protection of this legislation and the Constitution. So that's often something that's quite contentious. So I think those are the provisions of the Constitution that are relevant, and that provide the background and the enablement of the legislation, which Belinda and Sithabale will speak about. Then I would like to come to the time is quite short, so I can't be too long. But I then want to just briefly refer to the case that I have alluded to. It's the case of Daniels versus Scribante. I don't think we have slides for that, except just one quote that's found in that case, and you can just put it up again. Maybe people can have a look at that while they listen to me. So, but what I propose to do is to quickly explain to you what the facts of that case were and how the court dealt with it. And we don't have slides for that, but I will read, and I'll try and do it slowly. I'll read some of the most important paragraphs, which, as I say, the purpose of this is for the audience to understand how courts think about this, and as I say, very eloquent and quite intense and somewhat emotional placing of this legislation in the context of our history. The case that I refer to is Daniels versus Scribante. It's a judgment of the Constitutional Court in 2017. The facts, very briefly, were that Mrs. Daniels was a domestic worker who lived in this cottage on a farm, living there for 16 years. If I remember correctly, her husband had passed away, and she had some minor children with her. The landowner, instead of who wanted to get rid of her, to put it bluntly, he wanted to use the cottage for other purposes, and instead of approaching the court and the somewhat often tortuous route of litigation, tried to get rid of her by putting off her electricity, failing to she got a court order from the magistrate's court saying, confirming that she is an ESTA occupier and is entitled to the protections of the ESTA Act. And that was all good and fine, except that she then wanted to make some very minor improvements. She just wanted to level the floor of the cottage, and she wanted to install a small window. It was quite a windowless thing, and she also wanted to. The only wash basin was outside, and she wanted to bring it in. And she asked permission for this, and the landowner refused because they didn't want it there, to put it bluntly. So she then eventually approached the court, and she went through all of the steps and eventually came to the Constitutional Court. And the Constitutional Court took the opportunity to to explain to all who are interested, how this works and why we have this legislation. So I'm going to refer specifically to a judgment of Groeneman, Groeneman and Cameron, Justices Groeneman Cameron, who gave separate judgment, and I'll explain why they did that. But there's just an introductory paragraph in the judgment of Justice Madlanga, who spoke for the majority, and I read it. It's quite uncomfortable to read it and to listen to it. But I'm going to read it because it gives an indication and insight as to how the highest court looks at this legislation. And as I've said, one should adjust your expectations and your own approach accordingly. So he quoted from a speech that he came across that was given at some community meeting a long time ago in the old Eastern Transvaal. It was a community meeting. I'm not sure what it was about, but the speaker was an old man by the name of Petrus Nkosi, and Justice Malanga came across this, and he decided to quote it right at the outset of the judgment. So the quote is as following. Petrus Nkosi said the following, and it speaks to the same kind of thing that Richard referred to in the beginning. But he said, the land, our purpose is the land. That is what we must achieve. The land is our whole lives. We plow it for food. We build our houses from the soil. We live on it and we are buried in it. When the whites took our land away from us, we lost the dignity of our lives. We could no longer feed our children. We were forced to become servants. We were treated like animals. Our people have many problems. We are beaten and killed by the farmers. The wages we earn are too little to buy even a bag of mealie meal. We must unite together to help each other and face the Boers. But in everything we do, we must remember that there's only one aim and one solution, and that is the land, the soil, our world. I'm reading it quite fast because, we don't have that much time, and I don't want to belabor it too much. But I think when it gets the idea, it sets the tone for the rest of the judgment. The interesting judgments came from, as I said, Justice Groeneman, who wrote his judgment quite unusually in Afrikaans, and for a specific reason, because he thought that every demographic of the country should understand these sentiments very well. And what he did, and that's what I'm going to refer to because that's relevant to the topic, is he explained how the traditional ownership, the traditional notions of ownership of land has to be our understanding has to be somewhat altered, and I'm going to refer to just one or two of the passages that he gave. He fortunately also gave an English translation, so we can do it in English as well. So he started off by saying, anyone who travels through our beautiful countryside cannot help but notice that the living conditions of workers who live on farms do not always meet a standard that accords with human dignity. There is little doubt that things have improved, but unfortunately not uniformly so. Why not? That there can still be a debate about whether the applicant, Ms. Daniels, should be allowed to improve her home by doing ordinary things to make it more habitable without consent shows that we still have a long way to travel before the promises of the Constitution are fulfilled. Remember, what is at stake here is the leveling of floors, the establishing of a system of running water with a wash basin in the house. And then he goes on, and I'm not going to deal at length with the judgment. He goes into the history at some length, particularly the history of the Afrikaners and how they found themselves also in a position of poverty at one time. That's very interesting reading for those who are interested in culture. He refers to literature that is relevant, etc. And then he starts the conclusion by saying, what has all this to do with Ms. Daniels' appeal? Just about everything. the Carnegie Commission report on poor whites showed that poverty also and farms had nothing to do with inherent inferiority. And he says the burning injustice, namely, and there again comes the theme of justice. The burning injustice, namely that this corrective action was not extended to black and colored people, must and can be rectified. There is no reason to continue countenancing the continuation of unhuman and undignified living. And then to conclude, he had a whole section on the conception of property, and that is most relevant to this topic. So he says, inter alia, people like Mr. Scabante proceeded from the premise that the initial departure point of the inquiry into the evaluation of the validity of any right that Ms. Daniels may have must be ownership of the farm. That's how many people, I think about it. But it is a recurrent view of property and ownership that it is often used to delay or avoid the consequences of constitutional values. And then he goes on to say a conception of property creates a hierarchy of rights with ownership at the top. This is after some examination of the development of the concept of ownership in Europe, the feudal system, etc. So he says it's a hierarchy of rights with ownership at the top and lesser real and personal rights that may be in circumscribed circumstances, that may in circumscribed circumstances subtract from. Sorry, my tongue is getting all the talking. He says that this conception of property and ownership played an important role in the establishment of individual freedom in the development of Western capitalism does not mean that its continued existence in this form must be accepted as a given under the Constitution. And then he refers to the the quote that you see on the screen there. Then comes and refers to it's a quote, a dictum given by Justice Albie Sachs in one of the early cases dealing with these things, the PE municipality case. And he ends off, and this is where I end off. He says. Essentially, he says how to deal with this is there must be a attempt at balancing out the opposing claims, and of course that is not an easy task, but that's really what one has to do. So I'll end it off there. I think that gives one an idea of what this is all about and how to think about this. I think I might just end off by saying that. People are sometimes justified in being somewhat skeptical of this legislation and how the courts sometimes interpret it. Sometimes courts go too far, and that is also something that must be decried. I want to use the example of there was a case, I think it reached the news. It was quite a newsworthy case where the city of Cape Town's land invasion unit. There was a land invasion, and they were tasked with trying to prevent the people from actually establishing the dwellings, because once you've established a dwelling, it becomes a home, and then the Fire Act has to apply. And this thing was in the news. One of the would-be invaders, there was press and cameras involved, and international press and so forth, and he's kind of knew a good opportunity to elicit some sympathy and make the news when he saw one, and a good photo opportunity. So he decided to run into his dwelling, stripped down as if he was taking a bath, despite the fact that it was in the middle of the day. And the land invasion officials then dragged him out because, according to them, it hadn't been dwelling yet, it hadn't been a home yet, and of course the footage of the naked man being dragged out of his home, sent shockwaves through the world or through the country. And the only point I want to make is that the court, the Cape Court dealt with that matter in the case of the South African Human Rights Commission versus the City of Cape Town, and despite the fact that the court was aware of the circumstances and because the evidence was there about this stratagem that this person employed. To my mind, went slightly overboard, and I'm going to just read this paragraph very quickly, and that will be the end of my answering your question, Richard. They said on 1 July 2020, the nation was shocked by a video that went viral on social media depicting a naked man being dragged out of his shack in an informal settlement by officials of the city of Cape Town, who thereafter demolished the shack. The image reminiscent of apartheid era brutal forced removals depicted Mr. I won't say, well, I might as well, it's a public document, Mr. Bulelane Kolane, the third applicant in these proceedings. Those dragging him were members of the anti-land invasion unit of the city of Cape Town, a specialized unit tasked in failure with determining without a court order which structures should be demolished. And so it goes on. The only point I want to make is sometimes one feels that more sanity should prevail. This was clearly this was a man who, you know, we sought sympathy by conducting himself in the way that he did, and sometimes one feels that the courts should be more alive to the realities of these matters as well. So I hope, Richard, with that long answer, I have managed to provide an answer to the question, which is basically just to make one think about the concepts of justice and equity in the context of this legislation.
Thank you, Con. That gives the constitutional context. So let's turn to some practical application of the law. And Belinda, perhaps we can start with you. I know you've been involved in these matters and similar matters. Let's talk about the PI Act and when do you use it, and give us some insight into that with reference to your own experiences.
Thanks, Richard, for the introduction. Yes, as Con alluded to, it's not necessarily a straightforward answer as to when PI is applicable or not. I'm going to share my screen just to take you through some slides, and if you want copies of the slides, you're more than welcome to ask Andrea at the end of the session. So, sorry, let me just make sure. There we go. So the first question, the question that Richard asked is, when is PI applicable? So there's been a lot of case law around this. The leading cases I put up on the screen, and then obviously you have to turn to the Act itself to get guidance on where to go on this. So the first thing that needs to be taken into consideration is the occupation unlawful? So if your tenant is in there under a lease agreement and you haven't terminated the lease agreement, then his occupation is not unlawful. If he's in there when there is a termination and his notice period has expired, then he is an unlawful tenant and he's occupying unlawfully, and PI does apply. There was also a very interesting judgment which dealt with a sale and execution where the owner of the property had obviously defaulted and the bank had then sold his property in execution and they tried to evict him. However, they tried to evict him before the transfer had taken place to the new owner of the property. And the court said, well, he's still the current owner of the property and therefore he's not in unlawful occupation. Therefore, you can't bring an eviction notice for him and an eviction application for him in relation to this specific instance at this specific time because he's still in lawful occupation. So the first question is always, is there lawful or unlawful occupation? If there's unlawful occupation, then you've ticked the box to say that PI does apply. The other thing to bear in mind is that PI does not apply in circumstances where it's a rural property and the person that you're seeking to evict had previous consent to stay on that property. Then the Extension of Security of Tenure Act applies, and Sentebale, my colleague, is going to speak to that a little bit later. So if it's rural property and there hasn't been consent before, then you would still apply PI. But if these two elements are there, then you would have to apply under ESTA. There are a lot of similarities between the acts, but there's also quite a few differences. So you just need to know which act is applicable. And then the Act goes on to define that it involves a structure or building that's used for dwelling purposes. Now that's quite a wide definition, and our courts have gone a bit further, as Con alluded to actually say that this is applicable to a person's home. That's when PI is applicable to a dwelling. It's when it's their home. So. And this was defined in the Barnett case. And in reaching this conclusion, the court looked at the Act itself. And although there's no reference to home in the contents of the Act, in the preamble of the Act, it very specifically says that no one may be evicted from their home. So it's definitely something where the intention was to protect people from being evicted arbitrarily from their homes. And then he also said, if you look at the wording of the act itself, there's words like relocation and reside. So he says that again goes into the fact that it was meant that this is applicable to somebody's home. They also looked then at the Constitution in terms of Section 26(3), where the Constitution specifically says that no one can be evicted from their home arbitrarily or have their home demolished arbitrarily. So the court said it is quite clear that this piece of legislation was to ensure that people weren't arbitrarily evicted from their homes. So it's applicable to homes and nothing else. So then the question has been, and Con and I were involved in a matter which was decided by the Supreme Court last year, that's the Stay at South Point matter, where the question of what constitutes a home. So in Barnett, the court said there has to be an element of regular occupation coupled with some degree of permanence. In Con and my situation, it was we were talking about student residence, where there's obviously occupation and there's obviously a degree of permanence. But the court there did two things. It balanced rights, and it was saying if people are allowed to remain in unlawful occupation of student residence, then they're also infringing on students that are coming in seeking residence. In fact, they are breaching their rights or infringing on their rights to education, because a lot of students can't come to tertiary institutions for education unless they have accommodation in order to house them. So the court was saying, on a balance there, it's not. And the second thing is they have other homes to go to. They're not homeless should they be evicted. So the court in that instance actually decided A, it wasn't their home, and therefore B, PI didn't apply. In the Barnett case, the court also said that it doesn't apply to holiday homes because they're not homeless, and it can't just be a shelter from elements. So there has to be a large degree of intimacy, privacy, and it must be your safe structure where you would go, from the rest of the world. So they do try and limit it a little bit. There are a lot of cases where the definition has been used very broadly. So it is very much dependent on the circumstances of every case, and the court will start balancing rights out. And always bear in mind that when the court considers principles of justice and equity, they're considering it across the board. So not just the particular person. So they will look at the landowner and the occupier, and they will balance those rights out. So it's not just the rights of the unlawful occupier. So Richard, I hope that answers your question. And if anyone's got any questions on this, then they can put it on the chat, and then we'll address it as best we can.
And yes, maybe just from your experience, when you're faced with this situation, you now are a landowner, let's say you own a block of flats, and there are people who refuse to leave, you've terminated their lease, but they don't leave. What practical steps under PI do you need to take in outline?
Okay. Thank you for the question, Richard. So there's very specific steps that are placed in the Act that you have to follow. But then obviously over time, the case law is developed, and the courts also have certain expectations in their minds about what they expect people to do. So there is an expectation by the court that if it is possible that landowners engage with the occupiers prior to bringing the application to see if there can be some sort of remedy settled between the landowners and the occupiers. Again, Con and I had, for the same clients but a different matter, we had an instance where we were in court, and the court actually on the day ordered all the parties, including some parties that were not before the court, to go to mediation. And it was very awkward at the time. Con and I thought it was a bit obscure and it was a bit irritating for everybody. But what I learned in that process is we did go to mediation, and we managed to convince all the parties, even those that were not before the court at the time, to participate in the mediation process. And it was fascinating to me that there were a lot of underlying reasons, and those reasons managed to be resolved. And ultimately, everybody at the end of the day, I want to say, one, there were no evictions, our client was paid, and it was as a result of the court at the time very orthogonally deciding that this needed to go. So there is an expectation from the courts that there should be some degree of engagement, if at all possible. So just bear that in mind going forward. Also, I understand that these things are urgent sometimes, so it's not always possible. So we're not saying you have to engage. Just look at the circumstances, discuss it with us or your chosen attorneys, and just see how the best way forward is. The other thing the courts have said is when an eviction order has been granted by a court, it has to be executed in a humane manner, and there must be no discrimination. So you can't, for example, just, remove certain individuals and not others based on, race, gender, or whatever the situation is. So it's got to be without discrimination. And then there are instances in the PI Act where you don't require a consideration of alternative accommodation, and I'll deal with that in more detail later. But our recommendation is that if you can get that report from the municipality, you should get the report from the municipality. And also remember that alternative accommodation doesn't mean that you, as the landowner, have to provide alternative accommodation. It's the city and the state that are looked at as to whether or not there is alternative accommodation that they can provide. And then going into the technicalities of it, so that's just looking at the courts and what other expectations they have. Technically, looking at the PI Act, if you are bringing this application, what you would do is you would set out the grounds of your application, the relief that you're seeking in that application, but before you serve it on the occupants, and you have to also serve it on the municipality. So before you serve it on the occupants in the municipality and or any other interested parties that you have identified, you have to approach the court and say to the court, I'm bringing this application. I need directions on how you wish me to serve this application. It's very unusual. We normally just follow the rules of court on service. You serve by a sheriff or however the rules set out. But in this instance, you have to approach the court and you have to ask the court for specific directions. And then once the court's given that direction, you obviously have to give effect to it and serve as per those directions. And that service needs to be effected at least 14 days before you're due in court for the hearing. When you serve it on the municipality, we again suggest that you ask the municipality or you give a notice to the municipality to please provide you with a report on their alternative accommodation options and if there are any available. And then the Act distinguishes between occupants that have been occupying for less than 6 months and those that have been occupying for 6 months or more. There's not a massive difference, but there's one very material difference. And in our mind, it is a material difference, but you should still try and stick with the more arduous process just to make sure that you satisfy the court that they have considered all relevant circumstances. So under the Act, if it's less than 6 months, the courts have to apply principles of justice and equity. Con mentioned why, he went into great detail as to why this is the case in terms of our constitution and our history. And when considering these principles, the courts have to consider all relevant circumstances, including but not limited to, but they have to consider these circumstances that are listed, whether the people are elderly that you're seeking to evict, whether they're children, whether they're disabled, and whether the household is headed by a woman. And again, I'm just going to reiterate what I've said at the bottom there. Although the section doesn't specifically say you should get a report on the municipality, you have to serve the application on the municipality anyway. So you might as well ask them for that report and give it to the court for some consideration, because the court is going to consider all relevant circumstances. Then we're going to I'm turning now to whether it's 6 months or more that the person has been in occupation. It's exactly the same as the above, except in this one, you are required by the Act to provide a report on alternative accommodation. Again, I reiterate, you don't have to provide that alternative accommodation as the landowner. It's the municipality and the state that have to provide that report and say why they can or why they can't and where they can. So give very specific detail in that report. These conditions that are listed here, there is an exception that's listed under the Act, and it says, if it's a sale and execution situation, then the court isn't obliged to look at these specific circumstances. You don't have to look at these. In other circumstances, the court does have to look at them. And this is if you section 4 is if you bring in an application in the ordinary course. There is provision made under the Act to bring sorry, I've jumped ahead a little bit. Please forgive me. sorry, in terms of Section 4, the court must grant an eviction order if it is satisfied that all the requirements of Section 4 have been met by the landowner and that the occupier has shown no valid defense. Now, a valid defense would be if the occupier has shown the court that there are just and equitable grounds sufficient enough for the order not to be granted against them. And I've given you some cases. This is the leading case that speaks into justice and equity in a bit more detail, and also speaks to the fact that things need to be done in a humane manner. And again, if you read any of these cases, the underlying principle will always be justice and equity. And when the court grants the order, they again have to consider justice and equity when they give a date by when the unlawful occupier has to vacate. So they have to give that date, and then they also have to give a date by which the eviction order can be executed. So in other words, when you can actually execute an eviction if they don't vacate by the aforementioned date. The order can also include directions to the sheriff to demolish and remove certain buildings and structures. So that's the process under Section 4 if you're bringing an application in the ordinary course. If you're bringing an urgent application, it is possible, but there are very strict principles and that apply. So the first thing is it can only ever be an interim order. You can't get a final order on urgency. You must give notice, so it can't be ex parte. You can't bring it without giving notice to the occupant and the municipality. There will be truncated times and dates, so you can be assured of that. And then the following factors have to exist. So you have to prove to the court that there's a real and imminent danger of substantial injury to either property, injury or damage to property or person, that an owner's likely hardship exceeds that of the unlawful occupier that is seeking to be evicted, and that there is no other effective remedy. So you must bear this in mind when you're bringing urgent applications. Richard, I hope that answers your question, and I hope it's been helpful to our audience.
Thanks very much, Belinda. And I see there are questions coming through. As I said, please feel free to post those questions. We'll make every effort we can at the conclusion to give you the time panelist time. I see Connell's already volunteered to answer the first question, which I'll put to. But I think let's give Sentabale a chance to tell us about Esther and its relationship with PAIA. And also, we know, Sentabale, you've been involved in many cases involving this legislation, how to deal with it practically to make it work and to try to achieve the best outcome for everybody. Thanks very much.
Good morning, everyone, and thank you, Richard. And thank you, Richard, for the introduction. So let's talk to this morning about the extension of security of 10-year Act in regards to why actually there's this legislation. Okay, so the main purpose of the Act is to provide occupiers and residents and users of land who were not protected in earlier laws, and applies to all who occupy the land which reside outside of urban areas and who have permission, which is very important, of the landowner. So the rule of thumb is always to look at whether ESTA or PAIA applies, where are you demarcated, and if you are in a rural area, it's more likely that ESTA applies. Now, why has this legislation been adopted? Well, one of the first things was that it is there to facilitate long-term security of land tenure, to regulate conditions of residence on certain land, and also to regulate the conditions and circumstances under which those rights of persons who reside in that land may be terminated. And it also regulates the conditions and circumstances under which persons whose rights of residency has been terminated, and the second stage of it being that after the termination, whether or not they may be evicted. Now, I do want you to note that this must never be confused. ESTA rights and also PAIA rights to a certain degree must never be confused with acquisitive prescription, which deals with uninterrupted possession and control of land over a period of 30 years, which then would confer ownership of that land, which is a very different scenario. Now, there are some fundamental underlying rights that motivate the reasoning and rationale behind ESTA. One of them being the right to human dignity, the right to freedom and security of the person, the privacy, freedom of religion, belief and opinion and expression, and the freedom of association and freedom of movement. Now, one of the key definitions of what Esther deals with, and I'll go conceptually to it, is one being consent, the definition on family, more importantly, on what an occupier is. And let me just break it down. So one of the things that's quite important is on the issue of consent is that consent is the express or tacit consent of the owner or person in charge of the land in question. And in relation to the proposed termination of the right of residence or eviction, be a holder of a mineral right, includes the express or tacit consent of such holder. With regards to family, it could be a spouse, a child, a grandchild, parent, or grandparent. Now, an occupier could be a person residing on land which belongs to another person and who has, and this is very important because there's a distinction between the 4th of February 1997 and after that, because both consents given before have slightly a different legal outcome, but which are the labor tenants, a person using or intending to use the land mainly for industrial mining, commercial or commercial farming purposes is also excluded, and a person who has an income exceeding 13,625, which is obviously an amount that will keep changing subject to proclamation from the minister, the relevant minister. Now, I want to also then deal just as an introduction with the first case that we need to deal with, which is Klaassen versus Van der Merwe, and I will share the citations on the chat box with regards to the right of a spouse. Now, just to give you a brief background on Klaassen, the Constitutional Court was held to deal with this case. Essentially, the practice had been that the eviction proceedings, only the occupier was listed as the respondent and not the spouse of the occupier. In this particular case, the occupier and their spouse resided on a land approximately for 30 years. It was argued by the occupier that their right to reside came from the person from whom the consent to reside had been granted. They unsuccessfully in the land claims court were unable to convince the land claims court of this specific right. The spouse in the case had applied to be joined in the eviction, but was unsuccessful as the land claims court didn't want to refuse on the rationale of giving locus standi or right of standing to them. But the matter then graduated to the Supreme Court of Appeal, which upheld the land claims court's rights in regards to the fact that the occupier is actually the person that has actually been under the employ of the landowner. The Constitutional Court, in summary, had a different view to this, in which it said that that a spouse had an existing right, such as the right of equality and human dignity, and in considering these rights, a purposive approach is necessary. Now, what is this purposive approach? Well, using that approach, the Constitutional Court found that the spouse, particularly in cases such as a spouse to a land laborer working a land for a long period, and that employment then ceasing, is that specific spouse actually has a separate right to occupy the land, and such they are considered to be an occupier of the land separate from the actual main occupier. Now, just moving on to the issue of consent, one of the things that also needs to be looked at is what Rademeyer versus Western District Council also talked about, importantly with consent, that a person who has continuously and openly resided on land for a period of a year must be presumed to have consent to reside on the land unless contrary can be proved. In light of this case, consent is deemed to be present if the owner, if they did not give that consent, were aware of an occupier having occupied in their specific property. Consent is given by an occupier to reside shall not be terminated unless, in terms of this act under Section 8, which I'll go further to explain as to what those requirements are. A deemed occupier is provided that person resides continuously on the land, since consent has also been withdrawn. So there's a difference between you having consent and then once the landowner then decides to withdraw that consent but doesn't do anything further than actually just withdrawing their consent, because having you continuously live there without any further action, then it's deemed still that consent still exists. Now, a withdrawn consent shall be deemed to be valid termination if the right of the residents is then dealt with in regards to what the Act dictates as a valid termination. Now, what is actually this valid termination that we talk about? Well, a legal ground to terminate under the Act is that if the occupier has breached the provisions relating to a prohibition placed on the occupier, such as intentional harm to the property or the landowner and damage to the landowner's property. When the occupier has breached the material and fair term of any agreement reached by the occupier and the landowner where the owner has kept his or her part in the agreement. Where the occupier has committed such a fundamental breach of the relationship between themselves and the landowner that it is not possible to practically remedy in any other circumstance, such as, for example, as suggested by the Act, mediation, arbitration, and even court-facilitated mediation. Now, where an occupier is also an employee whose right of residence arose solely from the employment or has voluntarily resigned in circumstances that do not amount to a constructive dismissal, such in terms of the Labour Relations Act. In such circumstances, termination is also important under the Act. But what is always very important is that when you look at ESTA, is that you need to be aware that there's a two-stage approach. It could also be argued to be a three-stage approach. First, starting with the owner informing and notifying that I am hereby terminating and making effective notice of that termination. The second stage, once that has passed, is to go to what is called in your Section 9 to deal with the issue with regards to whether or not the person then fits, the occupier then fits the requirements for a lawful eviction. Now, it's quite important to look at regards to what the requirement then would be for lawful eviction, because it then speaks to what is notice and what is more importantly, the consultation process. Because one of the things and tenets of the Act that it does do is that it puts an obligation on owners to actually have this two-stage pronged approach in regards to your termination rights. And once you have effectively terminated in terms of the Act, the secondary part is that on that, is it lawful and that does it fit with regards to the requirements of Section 9 in regards to your eviction, which is the next step. Once an occupier has been terminated and 2 months have passed since the notice period, whether or not that person has actually adhered to that eviction notice that they were given by the landowner. Now, one of the things that is very important that the Act requires is that there must be effective notice given. But to whom must this notice be given? Well, first and foremost, you have 2 months. Then that 2 months can be the duration you've given in terms of your court notice or the notice you've given to the land occupier, but you are also obligated under the Act to also give the municipality the same notice. The Provincial and Regional Department of the Rural Development and Land Reform Department also. It is also best practice also to inform the SAPS so that any plans with regards to the incoming eviction need to also be developed. And also to a certain degree, depending on the facts, it's also a good idea to notify the Department of Health on the basis that there might be the elderly, there might be the sick and disabled, there might be minor children, which the social work and social development also must be. So on a case-by-case basis, assessing whom you want to evict and whom you want to remove from your property, there must be an assessment as to which government departments also to engage with. And the reality of it is that it's important because to be preemptive in the court to understand that there will be a requirement for you to prepare a plan, which is also known as a report. One from the municipality with regards to the relocation of the persons that are being evicted from under ESTA, with regards to the relevant departments, in particular, for example, where the SAPS being aware that there's going to be an eviction to provide the safety and security in the eviction plan that's going to be developed and proposed to the court. Your relevant health department having a plan on how to house the elderly, whether in old age homes, the disabled with regards to their treatment, the sick with regards to their treatment, minor children and social workers looking at the socio-economic principles of it. We've actually seen in one case in eviction in assisting a client in a large client in the Sabi district, evicting certain employees under ESTA, that it was actually very beneficial for us to actually contact social development because this specific landowner staff were plagued by alcoholism, which obviously with minor children involved us having to engage with social development to bring in some social workers, do a social needs assessment, which was also included in our report, so that in our papers in court, in 2 months' time following our notice, we were able to be in a position to submit a report that was quite comprehensive, also with a plan with the relevant government stakeholders, which with effective consultation, you're not going to get any resistance from, but more importantly, you can cite them on the papers and they can confirm exactly what the plan is as you plead in your papers. So why is this important? Because in terms of the Act, it's inevitable that a court will, if you don't provide that information, require that from what is called a report that deals with above issues. And it is best practice to consult and engage with stakeholders to get your papers complete and possibly for a specific, speedy and dignified resolution. Now, one of the examples of an effective termination is what is found in the case of Nimble Investments versus Malan. Now, what happened in this case? Well, Ms. Malan was a long-term occupier living in a cottage in a farm owned by Mr. Nimble. When Nimble required her to move to another cottage in the farm, meetings were held with her to get her to agree to relocate to an alternative cottage. She subsequently agreed to this, and eventually her and her family moved. Now, what's important to note is that Ms. Nimble actually was a 60-year-old elderly, in it, which is quite a protected class in terms of the Act and also in terms of our Constitution. But what subsequently happened in the move to the new property, to the new area that they were going to be moved into, the new cottage, is that her son and some unidentified household members then removed the roof tiles and certain building material from the old cottage and then built a structure akin to a shack on the adjacent to the new structure, to the new cottage in which Miss Nimble moved. In summary, the court found that actual vandalization and destruction of the old cottage without the permission of the occupier actually amounted to a material breach between the owner and the occupier. And in those circumstances, the court had agreed that actually eviction was a lawful step to be taken in evicting Ms. Nimble and her family, and subsequently ordered the municipality to actually provide a report in which the relocation of a planned relocation would happen of Ms. Nimble and her family to alternative accommodation outside of the farm. I'm not sure what I'm doing for time, Richard, but yeah, happy for you to continue other questions. I'm happy to also provide a few practical examples as well.
Yes, I mean, thanks, Nthabali. It's getting close to 10, but I think you mentioned the whole issue, and we discussed this in the preparation for this webinar. And Belinda mentioned it too, just the concept of engagement with occupiers before taking steps. And I know you've had some success and practical experience there. Perhaps just tell our listeners, the audience, what you've experienced and how it works.
Yes. So let me maybe use the Thabazimbi example, because that's a mining, the Thabazimbi iron ore mine and the eviction we had to deal with there. So basically with Thabazimbi, we were contacted about a year or so ago with regards to assisting Thabazimbi evict a youth development forum that had actually come to the mine and was granted consent to run offices. The mine subsequently discovered that this youth development fund was actually not running offices for operations. They had actually established an old age home inside those specific demarcated mine land, which was a problem for health and safety. It was a problem for the municipality. It was a problem also reputationally for the mine as well, should there be anything wrong that would happen by one of its properties that is not registered to do so, being running actually an old age home. So one of the first things we did prior to us even launching any papers under ESTA at the time was to actually contact the local municipality, the stakeholders, and also engage with the local ward councillor with regards to an appreciation. And we had numerous meetings, about 4 meetings, with the ward councillor, the relevant mayor and mayoral representative of the municipality, but also the Department of Social Development and Land Reform, and also the Department of Health, because we're dealing with the elderly, some of them having been disabled. Through that effective engagement, we were able to agree on a report and an eviction plan with the SAPS. The benefit of that being is that we were able to also agree on how the fact that they would be cited. We would not have an opposition to that, because what we would be averring in our papers in regards to the plan, in regards to the reports from the social workers who actually went to the premises and were refused entry to assess and make an assessment. And it was actually quite wonderful for them to, even through the state attorney, to give us a notice to abide, to say that yes, they fully agree that they were actually prevented from doing their government duties and what they employ to do, even the health professionals, in doing a basic assessment in that. So the court in that scenario in Mafikeng agreed with our application then for a lawful eviction and put a condition to the municipality in regards to the housing. So all the elderly were moved to a government old age home. With regards to the sick and vulnerable, they were then moved to a different facility, a health facilities, until the recovery. And those are the basic things that the plan also caters for. And it goes back to the reminder of why ESTA has actually specified specific Bill of Rights that on what needs to be covered and also what needs to be protected in regards to those rights. Thank you.
Thanks, Sandabali. That's an excellent example of how one can approach these matters practically. I see it's 10 o'clock. We've received some interesting questions, and feel free to post more. I think in fairness, we'll work our way down the questions, and some of them obviously overlap. I've read a question from Lesego who asks, what were the facts of the Daisy Deer Investments case, which was referred to, I think, in Belinda, but Connor's very kindly volunteered to answer that. So Connor, over to you.
Thanks, Richard. I just hope that I don't have a problem with my camera again, but you can hear me. I see I might have a problem with my video, but my audio is on, right?
Audio is perfect.
All right. So forget about the video for now. Oh, there we come. Yeah, it's interesting. It's just very a coincidence that this case is asked about, because it speaks to the very topic that Sebelane has just been dealing with, and that is the issue of mediation, or it's one of the issues that arose in that case. Very briefly, there was a large group of people who, unlawfully so, they didn't have consent to be on this property, but it was a community mushroomed into something like 2,000 people, and the municipality eventually decided that this constituted a health hazard, and brought an application to evict them, which they managed in the High Court. Went on appeal, and but they hadn't followed the PI for some of the reason, which difficult to imagine why, but they actually didn't follow the PI procedures, or the procedures prescribed by the Act. The on appeal, and the judgment was overturned on the basis that the PI Act hadn't been followed. It was said there's no excuse to say that these people constitute a health hazard. They are, they are occupiers, and you have to follow the procedure. What the court did, and that's interesting, is that it went on exactly about this point that that has now been mentioned. And so they said, for example, because the PI Act hadn't been followed, there was no attempted mediation. So they said that, and they actually, when a court of appeal delved into the matter, it was established that this group of people actually were quite amenable to mediation. They were not. The court ACO had accepted the proposition that these people had invaded this piece of land simply because they wanted to gain an advantage, as it were, because what happens is one of the things that happens quite a lot is people invade land, and because they know that there is this legislation, the Act has to be followed, the municipality has to get involved, and they can often negotiate, at least temporary alternative accommodation before an eviction was granted. But the court found that there was no evidence to support that, and found that there ought to have been a proper bona fide mediation. So it overturned the judgment, and it actually made an order that there should be mediation. And that's as far as that case went. One doesn't know what ultimately happened, but it was essentially that was the essence of that case. So yeah, it's quite apt to refer to it, because it talks about everything that Simelane has been speaking about as well.
Yes, and Con, just following from that, and this relates to another question. Somebody asked us, how does one stop as he puts, the mushrooming of informal settlements? Maybe one can talk to a practical example of how you deal with that.
Yeah, that is of course a big problem, and being in Cape Town, we know more about the difficulties and the challenges that the city of Cape Town face the whole time. I have myself been involved in some of these applications, so one must, again, one gets irritated by it, and you think it shouldn't be so difficult to have people evicted from unlawful occupied areas. But that was the purpose of my earlier speech. One has to bear in mind where this comes from. So you have many homeless people in this country, as a result of many things, economic situation, inequalities, etc. And it's a unfortunate fact of life that we have people who are homeless and who will do anything to get a home. In Cape Town, and I think in Gauteng as well, Johannesburg, people emigrate from other provinces quite a lot, and they seek means to obtain a home, lawful or otherwise. But it happens, and it's going to happen. And the PI Act is particularly the one that is relevant to that. And ultimately, when an eviction order is sought, the court has to look at what is just and equitable, and it looks at alternative accommodation and things like that. And the process is hard, and the solution is not easy, because for example, the city of Cape Town, I know, have established many what they call temporary housing, where they provide just a very basic means to and those are meant to be temporary locations, but they become permanent, because there isn't really a quick fix to these problems. A good example that I was involved in, one of the questions was also about how do you get rid of the vagrants, etc. A case that I think people might recall was quite a few years ago, but in Cape Town, in Green Market Square, there was basically an invasion of Green Market Square right in the middle city of Cape Town by foreign nationals. People don't like the word illegal, but I mean, they were not legally in South Africa. So that created a problem. I was involved in that, and you would think that you think it should be a no-brainer to remove people who are occupying the city center, but it's not. One has to unfortunately go through all of the hoops of the so-called PI Act. People have to be given an opportunity to oppose the application and say why it would not be just and equitable to evict them. Fortunately, in that case, it was ultimately successful in getting an eviction order, but it could have been a lot more difficult. They had probably not been properly advised, but I mean, none of them ever really went on affidavit saying they've got nowhere else to go. If they had, it would have been even more difficult. If an eviction application like that is opposed on the basis that the occupier says, "I'm going to go," because in the context of our constitutional dispensation, courts are reluctant to evict someone if they have got nowhere else to go. Where must they go? and it is a catch-22 situation almost. But again, the issue of mediation played a part there, because and so it's a recurring refrain. What then happened is that the city of Cape Town, went to a lot of trouble to make accommodation available and to gather all beds available in the shelters, homeless shelters around the city, in and around the city, and also embarked on a process of interviewing the people personally. Getting them. The offices were set up almost like a mass office where every single one of those occupiers could come and would look at their individual circumstances and where they came from. Where had they been living? Could they be relocated to where they were? Could something else be found? And it was only after that process was done that the court was ultimately prepared to grant an eviction order, and an eviction order was granted. The police came and they just simply forcibly evicted the people from Green Market Square. So that's the end of result. Sanity ultimately prevails, and eviction orders are not impossible to get, but it's a process, and it is. I see one of the questions was, about the cost, the legal cost involved. Yes, it is a torturous, often a torturous and costly exercise, and that is so because all of these protections are built in this legislation. But one has to accept it and live with it. And just deal with these issues as competently and as humanely as possible, then you will get the result. So I think that's, I don't know, Richard, whether that maybe provides an answer. There isn't an easy answer. There isn't a clear answer. It is an ongoing challenge. As long as we have these levels of homelessness, we will have these challenges.
Yes, I think thanks, Con. Another interesting question. Just find it quickly. Is this, in fact, really, I think probably better described as a cry from the heart. And I don't know if anybody can answer it, but let me read what happened. It says, after 8 years of property hijackers going to every pro bono clinic, I got an eviction notice. I served it on the authorities on the date of eviction, and after the eviction was effected, we received an ex parte application in the middle of the night brought by the COJ to take all the illegal occupants and hijackers back. We've been to court a number of times. The COJ missed every deadline set by the court to remove the people. It's been more than 1.5 years, and now even disagree that they have an obligation that was confirmed a number of times. This is worse than land expropriation without compensation. The use of my land has been expropriated, but I still need to pay the usual bank rates and taxes. What is my remedy? Now, that's obviously somebody's own practical experience of how the system works. Do any of our panelists, I'm going to allow you to put up your hands and answer, have a suggestion or an explanation as to why that has taken place and why it's been so difficult for this particular person? Any volunteers, please? What should that person try to do?
Richard, since no one else is volunteering, I will try. I'm assuming that those are it sounds to me that it's one of those hijacked buildings that one reads about in Johannesburg specifically. I'm not sure whether I got the whole question. We don't have that in Cape Town. We don't have those problems with the so-called hijacked buildings. And it's one has to know, I think, more about the specific facts of the case. I think on at a high level, the only thing one can say is yes. I mean, I don't, as I said, don't know the facts, and I don't know why the city of Cape Town, if I understand the question correctly, came back and gave an order that the people have to be moved back into the building. after if I understand the question correctly, after an eviction order was obtained. That sounds to me unusual, and one would have to know on what basis that was done. My only thinking about that could be that so either the city of Joburg or these occupiers themselves approached the court on the basis that the eviction had been unlawful for some other reason, because it's a fact that if you approach a court, I mean, as people would have seen from the earlier presentations, it is a fact that and it's a very clear injunction, constitutional injunction, that no one may be evicted from their home without a court order. So anyone who gets evicted without a properly obtained court order will find it very easy to go to court and say, I've been evicted without a properly obtained court order, because it's such a clear and strict injunction. So I don't know whether that possibly happened, but I think in broad terms one can just say again that the procedures that these acts provide, often somewhat onerous procedures. The courts will only grant eviction orders once they have looked at every side of the story, once these occupiers have been given an opportunity. And it's a long procedure, but properly handled. I wanted to end off my previous speech by saying that my experience has also been that properly handled eviction orders are not unattainable, and the system is not that bad that we should all be completely frustrated by it.
Yes, I see Senator Bali, you want to add to that? Perhaps you can come in.
Yeah, I think one of the things just to add to Cole's submission is that it goes back to what are the exact facts, and you would need to actually assess the facts more importantly. But what it does echo for me is why there's a fundamental need in these processes for adequate stakeholder engagement, you see, so that you actually understand, because it's quite, from the facts, if I'm looking just this, you can see a situation as to there was no plan after the eviction that should have been established. And also understanding the relevant stakeholders' interests that are being protected, because it's quite strange why an ex parte application from the COJ would have been launched in a situation where they know who the respondent would be and where the respondent could be located, and on what basis would they have then gone ex parte. So the facts for me are a bit, I'm not sure as to how they would have done that, but it's one of those cases that why the Act encourages effective stakeholder engagement, because this is one that probably also requires a bit of mediation and engaging with the COJ to understand, because that obligation unfortunately does rest with them. As much as they might be trying to say it doesn't, it does rest with them to provide adequate housing once establishment of ownership has been proven.
Thanks, Senator Bala. Belinda, you want to chip in something here as well?
Yes, I'm feeling Johan's pain as the messages are coming through. Johan, it is frustrating, and I'm sorry that you're in these circumstances. And sometimes ex parte orders get granted when they shouldn't. Our courts are not perfect. And unfortunately, it's just going through the motions that you seem to be going through at the moment. I mean, as both Khan and Senator Bali said, we don't know the specific facts of your circumstances. I fully appreciate that your eviction order was 100% done correctly. Otherwise, the court would never have granted in the first place. And it looks like what COJ is trying to do is actually just shirk its responsibility. And as frustrating as it is, and it may take some time, eventually the court is going to have to make them deal with it. And if you get an order against them and they don't comply with that order, you can do what another one of our clients has done and actually threaten to start arresting their directors for contempt of court. And I'm sorry this is happening. Other than giving you the advice that we've given you now without knowing more of the circumstance, it seems to be one of those where you just have to just carry on, trucking until COJ's actually brought to book.
Thanks, Belinda. I mean, and of course, we all know that these issues are sometimes, as we said earlier, highly politicized. And, there may be influence where there shouldn't be an interference in decision-making at that level, but that's obviously speculative. Another interesting question, and I don't know if we'll get to all of them, But here's a question. With reference to the provision of adequate housing, and this is the constitutional provision mentioned at the beginning of the presentation, many of the institutions for human settlement, state and municipal, create new townships, minimal infrastructure, services, roads, water, sewage, erect top structures, such as a precast concrete toilet cubicle, leaving their beneficiary of land to build essentially quote, squatter type housing, not in compliance with basic building regulations. Is that not in conflict with the Constitution? Anybody want to answer? Belinda, I see you've keen to speak. You go for it.
I actually answered it in the chat, so I thought, let me take this one. So yes, there is an obligation to provide adequate housing. And in Cape Town a few years ago, the people that have been living in Cape Town will know about this. The city of Cape Town was actually brought to book on certain restroom structures that they'd put up in the townships that weren't adequate, and they were actually a danger to the community. So the courts will look at that. It does require that somebody brings it to the court, obviously, but again, they will reiterate that things need to be done in a humane and dignified manner. So if there are legitimate land allocations for people and structures are put up to assist them, then they should be afforded the basic amenities, and that will not then infringe on their basic human rights. Remember that there's going to be a balance between what is a luxury and what's not a luxury. Is electricity a luxury or not? And I mean, the Constitution, the court has said it is not a luxury. I mean, it's not a luxury, it's a necessity. So it very much depends on what the services are at on site and how they've been implemented on site, and whether somebody's willing to bring the city, wherever it is, to book on or the institutions that have provided the land to book on what they've provided in terms of that land.
Thanks, Belinda. And the tangential question I would want to ask myself is, we were going to talk about land invasion. We never quite got there. It's a bit off this topic. But we often get questions about how do we prevent these things from happening in the first place? Because, of course, what you're dealing with here is when there's been an occupation and now you have to apply PI. Our experience has been that, especially for those landowners who are under threat, who have large tracts of land, whether peri-urban, rural, who knows, is to try to get early intelligence of when it might happen. There are security companies which provide that intelligence, and try to preempt that. And you preempt that by going to court to get an urgent interdict to prevent people from coming on your land, provided you can identify a group or people who might be doing it. And then you take the necessary steps to put up the order, provide security, and so forth. So it can be prevented if you act timelessly, and that's what we always recommend to clients. But another aspect which has emerged in this discussion and that's been raised in question is how helpful is the state or the municipality in dealing with these things? Somebody asked about how do you get these reports, and we have people who, both from Gauteng and Western Cape. It'd be interesting to compare and perhaps explain what you need to do to involve those authorities and how effective and quick that may be. I'll leave that to maybe Senator Bali. You can talk to that to begin with. Maybe Senator Bali can't, or maybe I don't know if he's still there. Are you there, Senator Bali?
Everybody hear me?
Yes, sorry, knocked off there. Now, what has your experience been like in dealing with the authorities? You talk about this cooperative process and getting reports. Are they helpful? Do they stand in the way? Do they take a long time? What's your feeling about it?
The reality of the matter is that you're dealing with people. It's not even a law question. It's just you need to understand you're dealing with people. Everyone remembers having to, at some point in time, go to Home Affairs or going to get your vehicle license done, and the dispute resolution mechanisms you need to work around in South Africa in dealing with that. It's just one of those things that understanding who your stakeholder is, but more importantly, understanding the fact that people want to be engaged. Dealing with it after the fact, people feel undermined. There's always a power balance in these issues. And I can guarantee you, we're sitting with an election year now in South Africa. There's going to be a lot of mushrooming and posturing and promises made to people, which give people entitlement to things like land invasions are quite common during this current season. And the reality of it, effective engagement can only happen by you taking the time. For me, as Sintibali, leaving my Sandton office and going to the COJ, for example, and saying, who do I need to talk to with regards to this specific issue? With regards to rural development, whom do I speak to regards? And we've developed those contexts over the years now to have, at least to a certain degree, a direct channel with relevant stakeholders. But the point being is that it's all about communication, because what you do with the communication, even when you reach a deadlock, is that you've created a nice paper trail for you to say to the court tomorrow, I have tried to be reasonable. I have tried all remedies. And as everyone in this forum will know, is that there's nothing more sweeter than actually saying, I've exhausted all remedies available to me and I have no alternative but to come to you, court. But rather put life to that statement to say, I have indeed tried. And many of the times, depending on the demeanor and the challenges that you will face, and a bit of patience and a bit of prayer now and again, you do get things across the line, because it's a matter of sometimes also educating stakeholders with regards to their rights and powers, and also enforcing, because you'll find actually the people on the ground, it's not a matter that they don't want to implement what you are saying. It's that they don't even aware that it's part of their rights and duties for them to execute. So sometimes you take even that role of educating them and actually becoming even a legal advisor to a certain degree to those stakeholders to say, these are the way forwards that you do. In actual fact, a well-planned report you can repeat in many similar key processes without you having to carry the cost in the future of it.
Okay, that's very interesting. So, I mean, one of our questioners said, he puts the word massive challenge for property owners where you have a dysfunctional state. Is the state as dysfunctional as people believe from your experience? Linda, you welcome.
And now let Sentebali answer your question. I can go back.
Sentebali, you obviously deal with the state. Are they proactive? Does it depend on your experience? Is it necessary, as you say, to develop those channels of communication to make it run more smoothly?
Yeah, it is this, Richard. The state is sued every day, cited. Sometimes there's something else from them. Sometimes it's just for notification purposes. Unless you actually take your papers and your issue and try and get to the person you think should be listening to it, the channel of going through the state attorney practically means your document is going to get to the right desk, maybe if you're lucky, within 3 weeks. We all know that the state attorney is understaffed, brilliant people in that department, but surely the amount of work they have to do, it's impossible to be dealing with so many files effectively at any given time. So you're not going to get your relief or the attention your file deserves or your matter deserves without you having taken proactive steps. One of the most practical things that I would do, for example, in a normal eviction, is understanding who I need to talk to first and foremost. So if it's the COJ, besides the legal department, that we do have those relationships in any event, to just say to them, as a courtesy, I'm also just giving you a copy of the papers as it is, happy to have a chat with you about them, but also with the relevant departments doing the same without usurping any of the state attorney's powers in regards to that. And then also writing to them positively to say, and also the tonality of your correspondences would be welcome to be a bit friendlier than the normal way lawyers like writing to the state. To say that as far as this issue is concerned, we are available to engage. Here's our dates. Please propose us dates that are available for you to be able to engage with us on these. It really, the solutions outside of your court processes, if done properly, make the court process much painless and unopposed in circumstances. There was a question, for example, on arbitration. Arbitration works. Don't get me wrong, it's probably a speedier process. The challenge only you have is the chances are the occupier might not want to participate in arbitration. And it also comes at a personal cost, which is also another thing. Now, are you going to be sharing the cost or are you going to carry all the costs? Which is more likely that you're going to carry all the costs because the person, if they fall within the means test to fall within these legislations, they probably can't afford the services of the fees of an arbitrator. So that's where, as much as mediation and all these things, there's a lot of cost, unfortunately, that the landowner would have to carry. So it's quite important to try as best as possible to engage so that you give yourself the opportunity and the lifeline. Apologies, the load shedding has just happened here, which means I'll have to have effective engagement with Eskom soon. But yeah, so it's just one of those things. We need to go back to humanity and say, We need to talk. That's all it is. There's no hard and fast formula to it. There's no hard and fast rule to it, but it's worked to just engage with people meaningfully.
Thanks, Ntobali. I see we're reaching 10:30. So firstly, I want to thank all the speakers, Con, Linda, Ntobali. Thanks for your insights. And also all the people who joined us. We really appreciate you joining us. We hope it was useful to you. I'm sorry if we didn't get to all your questions. Please feel free if there are things you want to engage us with or about after the webinar. By all means, send us an email or we'll go through these topics. We can follow up. And yes, well, thank you very much for joining and I wish you the best of the day.